Hey, folks, time to talk about something we haven't talked about in a while. Alex Murdaugh. Once he was convicted of double homicide of his wife and son. But the South Carolina Appeals Court, Supreme Court, overturned the original verdict. So now he is, despite many thinking otherwise, he is to be considered innocent again until proven guilty in a court of law. Now, that trial took forever. So the Supreme Court, well, most of their opinion was regarding Becky Boo, who influenced the jury. But also there were commentary from the Supreme Court justices that, yeah, you can't have all that financial stuff in it. So he's getting a new trial, and Alex Murdaugh wants Becky Boo to pay for it. So let's get into some reading. Yay! Here it is. Hold on. Here it is. Let me get myself on top of this. There, you get a bit larger, and of course we need there, Santa Claus. So we are first going to read defendant's motion to dismiss. Rebecca Hill. 2. Plaintiff Richard Alexander Murdaugh, Sr., by and through his counsel. You will please take notice that defendant, by and through the undersigned counsel, respectfully moves this court to dismiss plaintiff's complaint for failure to state a claim upon which relief can be granted, and or for this court's lack of subject matter jurisdiction pursuant to Rules 12b-6 and or P 12b-1 of the Federal Rules of Civil Procedure. Defendants moved pursuant to Rule 12b-6 of the Federal Rules of Civil Procedure for dismissal of plaintiff's suit based upon plaintiff's failure to state a claim for relief. Plaintiff alleges, in short, that defendant's actions deprived him of an impartial jury and that he is therefore entitled to recover the full sum of the money he spent on his criminal trial defense. Such damages fall outside of the scope of 42 U.S.C. 1983 and 88. The Fourth Circuit has never established that damages stemming from the legal cost associated with defending an underlying criminal case are redressable under the statute. Further, to the extent that other circuits have considered the question, they, along with the Fourth Circuit, have been clear in the event such damages are recoverable, and plaintiff must show that his damages were caused by the defendant's actions. Well, that line there sounds a bit like, well, you, Becky Boo, denied Alex Murdaugh a fair trial because you couldn't stop yourself from influencing the jurors because you wanted to write a book so you could buy a beach house. So, okay. Such cannot be the case here, where the entirety of the economic damages claimed by the plaintiff would have been spent on his criminal defense regardless of any action taken by this defendant. This here sounds like a circular argument. He can't demand money from me because he's going to spend it anyway on his defense. That's not a good argument, in my opinion. Similarly, and for much the same reasons, defendant is entitled to dismissal of plaintiff's claims pursuant to Rule 12b(1) of the Federal Rule of Civil Procedure, where the compensatory damages sought by the plaintiff are not traceable to the defendant's actions. Again, Becky Boo, the Supreme Court ruled that your actions in the trial denied Alex a fair trial. Finally, to the extent, if any, the plaintiff argues otherwise that, inconsistent with his complaint, he seeks damages related to the second future trial. Defendants likewise moves to dismiss plaintiff's complaint under Rule 12b(1) of the Federal Rule of Civil Procedure. Under such a theory, plaintiff's damages have not, and indeed might not ever accrue, and plaintiff's suit would therefore not be ripe for adjudication, divesting this court of jurisdiction to entertain the same. Finally, and most critically, even if plaintiff states a compensable claim, defendants is nonetheless entitled to 11th Amendment immunity, quasi-judicial immunity, and qualified immunity, all of which bars plaintiff's suit. Defendants' arguments and legal authority are contained in the memorandum of law submitted herewith. And here it is. Memorandum in support of defendant's motion to dismiss. So this is, Dun, dun, dun. That's the same words. Standard, okay. Same words there. Defendants moves to dismiss. Okay, so now they are citing a bunch of case law and more case law. And an argument. Plaintiff alleges that during the course of his criminal trial for the endings of his wife and son, which began on January 23rd, 2023, and ended on March 2nd, 2023, defendant Becky Hill had multiple improper contacts with and made multiple improper prejudicial comments to the jury. Yeah. That's not much of an allegation. That is a finding by South Carolina Supreme Court. The South Carolina Supreme Court set aside plaintiff's murder convictions and ordered a new trial upon finding defendant's actions were improper and presumptively prejudiced the jury's verdict. Plaintiff brings the instant civil suit under 42 U.S.C. 1983, seeking to recover compensatory damages for defendant's alleged constitutional violation of Murdaugh 6. What do you mean, alleged? I mean, that is a finding of the South Carolina Supreme Court. You did this, Becky. And not only did you, Becky, deny Murdaugh a fair trial, through your actions, his alleged victims are going to be forced to sit through a new trial. Because you decided money is more important than justice. Plaintiff seeks compensatory damages in the amount of $600,000, which represents the flat fee paid to plaintiff's legal defense team, a combination of attorneys from Griffin Humphreys LLC and Richard A. Harpootlian PA for their work in the underlying state criminal trial. Plaintiff does not contend defendant's alleged constitutional violation of Murdaugh's Sixth Amendment right to a fair trial by an impartial jury, secured against the states by the 14th Amendment, caused plaintiff to incur the additional legal costs of defending any post-trial and appellate litigation or future retrial. Rather, plaintiff seeks to fund such possible retrial pursuant to a novel theory of recovery under 42 U.S.C. 1993, contending that defendant's alleged constitutional violation cost the entirety of his underlying state murder trial and his economic loss of the funds spent in defense thereon. Well, it's not far-fetched, is it, Becky Boo? Because You're the reason they have to redo it. All of it. All of it. Let's continue. Fundamental principles of 1983's remedial provision bar plaintiff's recovery of legal defense fees incurred in connection with this underlying state criminal trial. Plaintiff's suit is based on a novel theory of liability and recovery. Now, folks, novel here does not mean it's made up. Novel means it is extremely unusual. Novel in a legal setting usually means this is the first time they are going to try this attempt of recovery. To the undersigned counsel's knowledge, this is a case of first impression. No federal circuit or district court has addressed the question of whether a criminal defendant who alleges their Sixth Amendment right to an impartial jury has been violated can recover damages for their legal defense fees occurred in connection with the underlying state criminal proceeding in a subsequent civil suit brought pursuant to 42 USC 1983. Yeah, Becky, because do you know why this is so unusual that many circuits haven't tried it? Because what you did has never been done before to that extent. A clerk of court meddling with justice the way you did is so unusual. There's practically no cases to look back on. It's that bad what you did, Becky. It's that bad. Remember, folks, if rights aren't provided to the worst of the worst, then there's no reason for the state to give them to the people we believe are innocent. So this here has really nothing to do with Alex Murdaugh. It has to do with how would you want a relative or a friend or a colleague be treated in court. That's what this is about. Even expanding this inquiry beyond the narrow scope of the Sixth Amendment, the Fourth Circuit has never directly addressed whether a 1983 plaintiff can recover attorney's fees incurred in connection with an underlying state criminal proceeding, as we just went through. Absent such guiding law, defendant turns to the general principles upon which 1983 remedies are based and to other circuits' treatment of plaintiff's theory of liability and recovery. The Supreme Court has, quote, repeatedly noted that 40 U.S.C. 1983 creates a species of tort liability. As such, the common law of torts, quote, provides the appropriate starting point for the damages inquiry under 1983. Yada, yada, yada. The general purpose of damages under 42 U.S.C. paragraph 1983 is to, quote, compensate persons for injuries that are caused by the deprivation of constitutional rights. Yeah, Becky, that would be what you did, in my opinion. And it's blah, 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 blah. Federal circuits are split as to whether 1983 permits recovery of legal fees incurred during an underlying state criminal proceeding. There's a split of authorities on the issue of whether criminal defendants whose constitutional rights have been violated in an underlying state criminal proceeding can recover damages for incarceration, legal costs and/or fees, or emotional distress in a subsequent 1983 suit. Towns versus City of New York, 1999, barring recovery of damages for attorney's fees and costs incurred in underlying criminal proceeding when evidence for gun possession charges arose from a violation of the Fourth Amendment. Burunda v. Richmond, recognizing recovery of money spent on legal representations, defense of underlying acquitted criminal charges as compensatory damages for economic harm. Defendants first addresses the Second Circuit's approach in Towns. The Second Circuit panel rejected the plaintiff's compensatory damages claim relating to his conviction and incarceration stemming from a Fourth Amendment violation. In his criminal trial, the plaintiff moved to suppress a firearm found pursuant to a stop and search of the taxicab in which he was a passenger. The plaintiff's motion was denied, and he subsequently entered a guilty plea for the charge of unlawful possession of a firearm. After 2 years of incarceration, the State Appellate Division reversed the conviction upon finding the police lacked probable cause to seize and search the taxicab, which subsequently resulted in dismissal of the indictment. The Second Circuit panel first held the fruit of the poisonous tree doctrine cannot link the unreasonable seizure and search to Towns' conviction and incarceration because this evidentiary doctrine is inapplicable to civil 1983 actions. Yeah, but this is by cops, Becky. You're not a cop. You're a clerk of court. There's a difference. The panel explained that the fruit of the poisonous tree doctrine is calculated to safeguard the constitutional rights of suspects by deterring future unlawful conduct by state actors through incentive, quote, avoidance of the suppression of illegally seized evidence, rather than by creating a personal constitutional right for the party aggrieved. The panel found that the doctrine's deterrence objective have already been achieved, though late, by the rulings of the Appellate Division and Court of Appeals, and reasoned that extending the doctrine to 1983 actions would impermissibly recast the relevant proximate cause inquiry to one of taint and attenuation. The Second Circuit likewise found that the plaintiff's incarceration was not proximately caused by the alleged Fourth Amendment violation. The panel determined the unconstitutional seizure and search of Towns' person was not a proximate cause of his conviction, because the trial court's refusal to suppress the evidence was an intervening and superseding cause of Towns' conviction. In broad terms, he pled. Yeah. So that is not the Second Circuit are basing the ruling on, is that, well, that search might have been unconstitutional, but he still pled. Problem for Becky is that Alex didn't plead out. He was actually convicted. So it's not cops and it's not a plea deal. So it's harder to argue this, in my opinion. Thereafter, the panel discussed the second independent reason for which the plaintiff was foreclosed from recovery. Recovery of compensable damages was improper where the injury pleads does not fit the damages he seeks. The Second Circuit panel pointed out the gross disconnect between the constitutional violations and the injury or harm for which Towns seeks a recovery. Explaining the evil of an unreasonable search or seizure is that it invades privacy, not that it uncovers crime, which is no evil at all. The panel concluded this gross disconnect ran afoul of the Supreme Court's directive to tailor 1983 liability, quote, to fit the interest protected by the particular constitutional right in question. Moreover, the panel reasoned that no Fourth Amendment value would be served if plaintiff reaped the financial benefit sought in addition to already reaping an enormous benefit by reason of the illegal seizure and search to which he was subjected, his freedom. This is the Second Circuit saying Yeah, but you're free now. So never mind. You were wrongfully incarcerated for 2 years because you're free. Congratulations. The panel Alternatively, in Burundi, the Ninth Circuit rejected the appellant's contention that admission of the amount of attorney's fees expended by respondents during the prior state court criminal proceeding as an element of 1983 damages was a prejudicial error. The Burundi respondents were previously charged with resisting arrest, assault on an officer, and public intoxication by the appellant officers. After a jury trial, the respondents were acquitted on all criminal charges and subsequently brought a 1983 action against the appellants. After a 4-day trial in the 1983 action, the jury returned a special verdict in favor of the respondents, awarding them both approximately $11,000 each. First, the panel quickly disposed of the 2 cases cited by the appellant in support of this proposition as inapposite, because the cases involved attorney's fees awarded pursuant to 1988, not 1983. Next, the panel found the respondents' expenditures for legal representation during the prior criminal proceeding most assuredly constituted economic harm, which is a compensable injury under 1983. The Ninth Circuit panel held that the reasonable amount of these expenditures for legal representation is proved to the jury's satisfaction to be the consequence of appellant's illegal conduct is recoverable as compensatory damages. The Ninth Circuit panel rejected the appellant's argument that their illegal conduct did not proximately cause the expenditure of attorney's fees in defending against the criminal charge because the prosecutor's decision to prosecute the case was an intervening and superseding exercise of independent judgment. While recognizing that the prosecutor filing the criminal complaint is presumed to have exercised independent judgment in determining that probable cause for an arrest exists, the panel found the petitioner has submitted sufficient evidence to challenge the presumption. The panel determined, based on the evidence presented, the jury was entitled to find that the appellants procured the filing of the criminal complaint by making misrepresentations to the prosecuting attorney. The amount of attorney's fees incurred during the criminal prosecution was a direct and foreseeable consequence of the appellant's unlawful conduct. So the argument here from Becky Boo is what she did not directly inflict the damage. They claim, well, the evidence in the trial was produced clearly. Becky Boo only influenced the jury for monetary reasons. So it's different than this case. Therefore, she should not pay Alex Murdaugh. The third and seventh circuits have adopted the town's rationale and rejected Burundi. Defendant urges this court to do the same. This court should adopt the Second Circuit's rationale barring recovery of legal fees incurred during an underlying state criminal proceeding in a subsequent blah, 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 blah. And then it's more or less the same here. Then the Kerr verdict. Let's go down to, because it is basically the same type of argument throughout their motion. Okay, let's go here. Finally, even if this court were to accept this speculative theory of recovery, the relief requested within the complaint is far beyond any actual cost of attorney's fees incurred. At first blush, By way of simple estimation, it facially appears the plaintiff could only show he incurred $165,000 in attorney's fees in his underlying criminal trial, even possibly related to the defendant's alleged constitutional violation. Assuming plaintiff's complaint is a true reflection of the attorney's fees incurred in the underlying criminal trial, and assuming arguendo that his attorneys were paid only for the days upon which plaintiff was on trial, plaintiff incurred $15,000 in attorney's fees on each of the 40 days that he was on trial. Oh, this is now this is a novel argument. So what Becky Boo did here, or Becky Boo's attorney, is they took the flat fee and then expanded it. That each day cost Alec $15,000. Therefore, only the days at trial should be recoverable, not anything pre-trial. My consideration here is, well, pre-trial will incur again. They are starting over because your action forced the court to start over. So claiming, well, I only misconduct on the actual trial, yeah, but this is not just I only caused it on that day, that day, that day, and that day. It is what was the result of your conduct. How much did it affect? Well, it affected from the day they took the case, because now they have to start over, in my opinion. Plaintiff's asserted injuries, loss of attorney's fees in his underlying criminal case, was not caused by defendant. Really. Further, any potential causal connection linking the loss of attorney's fees to defendant's alleged constitutional violation is simply too speculative, too attenuated, and too weak to support Article 3 standing. The damages alleged by the plaintiff were not caused by the alleged constitutional violation by defendants. Let's see here. The footnote here is interesting. While undersigned counsel submits it is safe to assume that the work for which plaintiff's defense lawyers were being paid began well before January 23rd, 2023, trial date. For the purposes of this motion to dismiss, defendants assumes arguendo the date of the first payment was January 23rd, what? First payment was on the first day of trial? Really? Defendant only makes this assumption at the current stage of the proceeding because the discovery process has not yet developed. Defendant will, of course, update the accuracy of these calculations upon plaintiff's provision of evidence demonstrating the date upon which payment began, the total amount of fees received, and the itemized cost for which the funds accounted for. Another interesting argument. I don't buy it. Doctrine of ripeness, yada, yada, yada. Oh, look at this. This is defendant is entitled to immunity under the 11th Amendment and under the doctrines of judicial immunity and qualified immunity. Oh, this I want to hear argued in court. Becky Boo, convicted Becky Boo, removed from her position, found in the Supreme Court, in South Carolina Supreme Court, that she was lying, colluding, and influencing jurors. Now she claims she has immunity. Here's the thing, Becky Boo. Your actions in that trial led you to be removed from the position. I'm not so sure your immunity applies. But I would I want to see the answer to this. I really, really want to see the answer to this. This was submitted to court June 18th, so just a few days ago. So an answer to all of this is some time away. As alleged, Supra, plaintiff's complaint, is subject to dismissal pursuant to blah, blah, blah. However, to the extent, if any, that this court finds that plaintiff's complaint is not subject to dismissal based on his failure to state a claim and lack of standing, defendant would nonetheless be entitled to such dismissal based on her immunity under the 11th Amendment, under the doctrine of judicial immunity, and under the doctrine of qualified immunity. These immunities are properly raised in the Rule 12 motion, where the Supreme Court has held that such immunities are immunities from suit rather than mere defenses to a liability. Such immunities are effectively lost if a case is erroneously permitted to go to trial. Here, defendant is entitled to immunity under the 11th Amendment. Plaintiff alleges that defendant is a constitutional officer of the state of South Carolina, elected as the clerk of court by the citizens of Colleton County, and that the action taken by defense were taken within her official role. Similarly, defendant is entitled to quasi-judicial immunity where the actions complained of by the plaintiff were judicial in nature and are related directly to the defendant's judicial responsibilities. Oh, this is quite a big leap here. A constitutional officer is not the same as a prosecutor. It's not the same as a police officer. I have to... quasi-judicial immunity when acting as an extension of the court or performing tasks integral to the judicial process. So quasi-judicial immunity. Let's see here. Fund covers roles. Dun, dun, dun. Quasi-judicial immunity can be absolute, and also it cannot, or qualified. Yeah, an absolute immunity is a complete bar to civil lawsuits protecting both right and wrong decisions, or the qualified is protecting officials acting in good faith. Well, we know you didn't act in good faith. This will be really, really interesting to hear the South Carolina courts to address this. This is fun, folks. This is fun. Let's continue. Finally, defendant is entitled to qualified immunity where it was not clearly established at the time of the alleged constitutional violations that the defendant's actions violated the plaintiff's rights under the 6th Amendment. As plaintiff alleged in his complaint, former Chief Justice Jean Toll denied plaintiff's motion for a new trial, finding that defendant's conduct amounted to harmless error. Yeah, here's the thing with Judge Toll and how she wanted this to be appealed. Because there were two situations, either harmless error or or the actual law, actual statutes. And the Supreme Court knocked the judge on the head and said, no, you should have known this all along. So I don't think, again, not the most promising argument here. The South Carolina Supreme Court reversed the decision, acknowledging throughout its opinion the difficulty, the complexity, and the conflicting jurisprudence of the Sixth Amendment inquiry. The violative nature of defendant's conduct then was neither readily apparent nor obvious to former Chief Justice Toll, nor to the South Carolina Supreme Court. It could but have been wholly lost on defendant or any other reasonable clerk of court. That's not really convincing. And then she claims immunity under the 11th Amendment. This is the 11th Amendment to the Constitution of the United States of America establishes that the judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state. This withdrawal of jurisdiction effectively confers an immunity from suit. The Supreme Court has consistently held that an unconsenting state is immune from suits brought in federal courts by their own citizens as well as by citizens of another state. Yeah, but this is not another state. Or am I reading that wrong? Tell me in the chat. Tell me in the comments. Absent waiver, neither state nor agencies acting under its control may be subject to suit in a federal court. Okay. Further, 11th Amendment immunity extends to arms of the state, including state agencies and state officers acting in their official capacity. Because a suit against the state official in his or her official capacity is not a suit against the official, but rather it's a suit against the official's office, and is no different from a suit against the state itself. Therefore, 11th Amendment immunity protects state agencies and state officials sued in their official capacity from liability for monetary damages under 42 U.S.C. 1983. The South Carolina Tort Claims Act expressly provides that the state of South Carolina does not waive 11th Amendment immunity and consents to suit only in a court of the state of South Carolina. As plaintiff notes in his complaint, defendant was at all relevant times acting as the clerk of court for the Circuit Court of Colleton County, South Carolina, a position to which she was elected pursuant to Article 5, paragraph 24 of the South Carolina Constitution. The Colleton County Clerk of Court's office is funded by the state of South Carolina. Unquestionably, defendant then is being sued as an arm of the state. She has neither waived the protections of the 11th Amendment nor consented to suit in federal court. Accordingly, she is entitled to 11th Amendment immunity. Must say I don't know enough about this to have an open opinion. I'm me personally not convinced. If you're practicing in South Carolina, you tell me. And then it's the quasi-judicial immunity. So she argues all the immunities and hope that one sticks. And qualified immunity, yeah. Let's go down to the final part here. This is too much to read in one video, folks. Too much to read in one video. There. Okay, now the Okay, so it's more conclusion. So, folks, Becky Boo really don't want to pay for what she did. And I understand why. Now, folks, I'm not a fan of Alex Murdaugh. I have issues with two pieces of evidence in the trial, which gets me listen to my wording here. The way the state presented the case at trial, that he and he alone did the deed, I don't buy. I really don't. Was he responsible? Probably, but that was not the state's case. Now, what are the two things? Well, the aim of the shotgun. According to the state's case, the angle and how far away the muzzle would have been to, well, the target, excuse my language, would have meant that the butt of the shotgun would have been more or less on the ground. And that's not really a good position. And the second and the strongest is Maggie's phone moved after Alec provably was no longer near the estate. But I don't blame people for finding him guilty beyond reasonable doubt. I really don't. I understand why you would reach that. I also know my bar for beyond reasonable doubt is higher than most others. But with the new trial, whenever it happens, not this year, we will see what this new trial will result in. Now, for Becky Boo, I think she should have to pay the entire amount because she denied Alec the right to a fair trial. She now forces the witnesses to take the stand again. Now forces the remaining son to sit through it all again. Yeah, Becky. Not only because you should, but also as a deterrent against all others who work in the court system, who gets the thought, maybe I should nudge it just a little bit. And no, sit down, shut up, and do your job and only your job. All right, folks, that is what I had for you for today. Thank you for showing up. And remember, folks, hug your family. Unless your family's crap, then screw them and give your love to the people who deserve it. Okay? See ya. Bye-bye.